Welcome to Solving Citizen Legal Encounters. All right, as promised, I have the follow-up to the landlord-tenant case that I uploaded a couple of months ago. And the question that I had during that time was if he was really a sovereign citizen. We'll find out in the second hearing. So what I'm going to do, I'm going to play the first hearing for those of you who may not have seen it, and then I'll have the second hearing behind it. Okay, so I'm not going to give it away, but I have the original footage that I'm going to go ahead and use for the first one. So it'll be an intro because I explained everything then. So I'm just going to let that ride and you'll see me in that video. And then the second one, we'll move on and we'll get the disposition of it, okay? I'll have everything split in the timeline. So for those of you who already seen it, you can skip it. The audio gets in and out a little bit at times, but I fixed it so it's not too bad. Let's go. All right, today we have a sovereign citizen who's in a tenant-landlord dispute in court, okay? Now, this sovereign citizen may not speak a whole lot of the sovereign citizen language, but after he says his name, he says one of those quotes, but the audio didn't catch it good enough. In this case, this sovereign citizen wants to go to jury trial because he didn't pay his rent. Huh? Now, who does that? A sovereign citizen. So we're going to go in, check out the case. You'll make your comments and we're going to take it from there. Okay? All right. Let's go.
Okay. What's your name, sir?
DK Enya. Myself.
All right. Thank you, Mr. Enya. And so we're here for, let's see. We're last here on this. This is a landlord-tenant hearing. It's a motion apparently to set aside a default judgment, but this is not a default judgment. It's a consent judgment.
Roger, I actually see. It's not here for me. I mean, that's parties that actually but I did not get into quickly on this. So this should be set aside.
Okay.
With Mr. Yeah, did I say that correctly? Yes, with Mr. Enya. Although they agreed in an email that if we don't agree today, it's what happens. So I'm do this in
Well, let's see. It's just something I can easily figure out, or I probably need to take some testimony.
You both didn't take this.
Okay, so we'll have to do it another day. So what we'll do, sir?
I think first of all, is we need to set aside the judgment.
Well, I was going to say that.
Yeah, and go over some other aspects of the case that need to be addressed. Because if the judgment is set aside, I was not properly served with the demand of possession. So I think that the whole process needs to be started over.
Okay, well, then you want to have them reserve the whole lawsuit on you.
Have to do that.
Well, let me see. Let me see what your motion says. He was agreeing to set it aside, but if you want it totally dismissed, let me see.
Well, the facts for the dismissal may be separate from the facts of the motion, but I could also present.
Sir, I'm not sure. So what I'm going to do is I'm going to read what you said so that I can be clear on what your argument is. Because typically, if you were served, but there was some other good cause or defense as to why you didn't come, then they're agreeing to set it aside, and normally we would go to trial. But if you're saying you didn't get it and you were never served at all,
I wasn't given to the two services necessary. I was only served as a posting to my door. I wasn't served.
That's okay in landlord-tenant. You don't have to be served right to your hand.
I didn't get the mail service or the email service.
Sir, let me say this. The whole reason why we do the 2 or 3 is so that one of them gets to you. The only thing you need is something, what we call it is efforts that are reasonably calculated to give somebody notice of the lawsuit, because we don't want you to get a judgment you didn't know. Okay, so that's why we make lawyers that are plaintiffs counsel in these kind of cases do 2 or 3 different ways. So if you didn't get it one way, you get it the other way, at least you have notice. So is that your argument, that you got it one way, but you didn't get it the other two?
Well, just in terms of moving forward, I thought that was relevant because by the time I did get the notice to my door, it was just really days before.
So that's usually how it works in landlord-tenant. People get it 1 or 2 days before, and then they got to get here. The idea is to make sure you at least have notice, not that it's convenient.
Yeah,
2 different things.
So legal.
Yeah.
Counsel or anything.
Well, I'm going to go ahead and grant the motion to set aside the judgment. Mr. Groomer says that there was some questions even about amounts that need to be worked out. Would you agree with that?
Oh, yes, definitely.
Okay, let's see.
Some other aspects as well I'd like to
Hold on, let's do this one. Mr. Gromer, can you do an order setting aside the default judgment, please? So you want a written response as an answer, or we just want to set it for trial? Okay, so, motion to set aside. Okay, let me tell you what I got.
Was there what, was this not at the first hearing? Sorry. Sorry.
Let me tell you, just hold on.
Sure.
Yeah, I see I think Mr. Palace's office was here for this before. And it looks like that was on February 6th. We had a hearing January 23rd. They requested adjournment then to confirm some payments had cleared and had been applied to the balance due. So then we set it for the 6th of February. On February 6th, a consent judgment of possession was entered. So he had agreed to it,
Yeah, I agree those numbers are wrong, which is why.
but the numbers were wrong, I guess.
They have.
And he had a payment arrangement
Yeah,
too.
they did. And Your Honor, but if we could just set this for.
Okay.
I would like to request a jury trial.
Why didn't you request a trial before?
No.
This is not our first time here.
Yeah, well, being that the consent judgment is being set aside, it kind of resets it to.
Okay. Sir, let me just ask you a question, and you certainly have a right. No one is ever going to take that right to a jury trial away from anybody. You know how to try a jury trial, though?
I'm sorry.
Do you know how to try a jury? It's a lot of work.
Yeah, I'd be bringing in
You gonna have a lawyer? Well, why don't we do this? Let's let you get your lawyer and let's set it for a quick pre-trial so that we can have Mr. Gromer talk to him and we can define whatever issues we have here and set a trial date that's within the lawyer's schedule. Do you know who it is you're gonna have?
I am speaking to a couple of lawyers.
Okay, let me give you the backstory real quick. This started in November 2024 for the non-payment of rent that was filed. There's been some other things going through the works, through the system, and then this hearing was scheduled. But he did have two other hearings that I missed, okay? So he had plenty of time to consider an attorney in the other two hearings as he knew he was approaching this one. So a motion was filed for what they're discussing right now. But all of this time, he could have had it done. So you know the attorney that he's mentioning or the two attorneys he's talking to, that's a delay tactic, stall tactic right there. So I'm sure we already know how this is going to go in the hearings moving forward.
But you haven't decided yet? Okay, let's do a quick pre-trial then.
I would obviously request this for.
Okay, I'll make a note. The defendant requested a jury trial.
Your Honor, I understand people have counsel, but if he doesn't have counsel, obviously the reason I've asked you for the dates is he was here on January 20th. Presumption was that he was read his rights, like he does. So you would have 5 days to place that in. So that date would have been January 28th. March 20th is requesting it first. Believe it. It's obligatory that you must do so.
I'm pretty sure I would have read those because we do this every Thursday. And what we do is have everybody sit down and watch the advice of rights video in the court. Then when I enter into the consent judgment, I ask you, did you watch the advice of rights video? Did you understand the rights? If you didn't watch it, I tell you what the rights are again. If you did watch it, I ask you if you understood the rights and if you wish to waive the rights. So that's why I asked earlier, why didn't you just ask for a jury trial then? But you know, at that time you entered the consent judgment and thought that that was correct.
Consent judgment, once I reviewed the facts and had the pertinent information, I saw that it was incorrect. So going forward, I immediately felt that it would be probably my best interest to have a jury trial.
Okay.
But of course, I couldn't make that decision until I came here today.
Okay. All right. Well, Mr. Gromer, if you want to brief it for me, because right now we have a situation where he was advised of the rights, he and no entered into a consent judgment, which everybody agrees was wrong, which we've now set it aside so to allow him to have a trial. So why can't he now ask for a to have a jury trial?
Because the court rule is specific as to us first hearing. I'll remind President, first told court they didn't even have time for that consent judgment date, and we now find out there's a hearing days before that judge. So I know a lot of say this nice, not about a lot of truth in the courts and court. So I don't believe the court rule changed by this year. Two separate occasions. An answer. All the motion still hasn't done that in writing to request.
You know what? Because you're right. It wasn't just the first hearing that he did enter into that judgment. It was the second hearing.
The first time we came to court,
That's when I gave you the rights.
the first,
Way back on January 23rd.
I think the proceeding was adjourned. Because,
Well, yeah, but it was.
and at that time, I in good faith was looking to mediate this issue. This is my homestead. It's not a business. So this is where I try to find peace. Upon trying to mediate it, actually, I would say that the plaintiff is the one that did not present properly to the court with the amount of probably settled this by now. But being that there are other issues like damages as well as injury to me as a defendant, with reference to the and I think that the relationship is irreparably damaged because I've been informed that although they've offered me a lease renewal, they are going to be rescinding that. So I think there are some pertinent issues to address and covered, and I think that I would like to do that at a jury trial if the court so pleases.
Okay. Well, we're happy to give you a jury trial if you're eligible, but there is a rule that says you have to request it on the first appearance or within 5 days of that first appearance, where I advise you of the right to a jury trial. So I'm not sure if you decided that you thought you were going to settle is a good reason not to have requested a jury trial just in case.
We weren't settling. We're looking for additional numbers to make sure that we have the pertinent facts that they weren't presented at that time.
Somebody's going to have to give me some law on this because he's objecting, so I'll ask him to do it. But what he tells me is that, which I know, is that you do have to request that jury trial on the very first appearance, no matter what you think you're going to do, or within 5 days of that appearance.
I didn't have an opportunity to do that on the first appearance because it was adjourned.
Sir, you could have gone downstairs and gotten the file and just filed it. It's just a piece of paper.
Well, we didn't, the proceeding didn't.
Okay, but I don't know that there's any exceptions in the rule that says about right to jury trial that you can say, well, I thought we were talking, so we adjourned it, so.
Well, no, not because we were talking, but because they didn't have the correct numbers.
Okay.
They didn't have the correct information to see.
But I don't think the rule has contingencies, is what I'm saying. That, okay, I was going to enter consent judgment. The numbers weren't right, so I didn't ask for a jury trial. I'm not sure that the rule makes exceptions for that. You have a little bit of a unique situation because you did enter into a judgment and now you're trying to set aside, which basically starts from scratch. So my argument, or my question, I'm not arguing anything. My question is to Mr. Gromer, in that circumstance where it's obviously not his first appearance, but he had decided the case and everybody agrees it was incorrect. Does the rule does this make it like a new case? Because we just set it aside and everything starts over. So why couldn't he demand a jury trial? So if you could please just look it up for me.
I'd be happy to look at it. Obviously, he's a moving part. So we really his motion.
Well, you're objecting.
Well, I am because the first hearing,
Yeah.
the rules that I obviously don't read the rules to any
Right.
court. Here on the 23rd, date would be 28. He's talking about entering into a consent judgment. It's saying that a mistake was made, obviously. No, the court isn't.
I'm not saying that at all.
So,
Mhm.
a jury trial. respond to that. Sure.
So he just requested it today. So you know what? If y'all want me to do this work, because he's not gonna be able to do it, what I need to know. So I'll take it on. I'll do it. No, I'll do it. Don't worry, Mr. Grower. I got resources. You can look.
There's a motion with board.
Because he's not gonna be able to do it.
Did it on the other one. Figure out this and I'm just making. See, scroll, I do it.
Sure.
Your Honor, if I may.
Yes, sir. What would you like to say?
So for the January 23rd date, where there was an adjournment requested by the plaintiff lawyer, although the lawyer has changed, that was the adjournment.
No, it's not accurate at all.
I'm speaking, so.
Okay, well, let him finish, Mr. Groomer. What is it?
So being that the plaintiff attorney asked for the adjournment on the 23rd, it was an adjournment, basically, or continuance, of the same proceeding on the 6th. Doesn't that count as a first appearance coming in on the 6th with relation to them not being prepared to proceed with the case?
No, first appearance is the very first summons and complaint date that you get served with, that you show up on. That, the one that we set, that is the first appearance. Anything after that is a second appearance. This is the third appearance.
I guess I didn't understand my rights then.
Yeah. I don't know why, because I show a video, and I show it every time. I have a full landlord-tenant docket. We show this video. I know when I entered your consent judgment that I reminded you about what those rights were. You said, yeah, I understand them and I'm waiving them. And they were the rights in the video, which one of the rights clearly says you have a right to have a jury trial. And if you want one, you have to fill out the form. I give you the form number. I tell you, you have to file that on your first appearance or within 5 days of the date that you've been advised of your right to a jury trial.
So basically meaning that the motion is now set aside, we're resetting the entire process.
Yeah, well, we're resetting for trial. And the question that Mr. Gromer decided that he would look at for the court, but I'm going to look at it too, is whether or not you even entitled to a jury trial under this circumstance where you didn't ask for it the first hearing. You entered into a consent judgment that was wrong, and now we're starting over. Does that really absolve you of the right to have requested the jury trial in the first hearing? I'm not sure what the answer is. He thinks it's no. You should have filed it, but we'll see.
Well, I have a duty to the court to be actual.
Yeah, he's not supposed to lie to me now either.
Well,
He advocates for his position, but he's got to, give me some information concerning that.
might be.
And you can do the same thing, mister, because let me tell you, your motion is here. You can go out there and research what you can and come back and show me what you can. But you'd be surprised what you can do, even though you're not a lawyer. Folks come in with case law and sometimes they're accurate. So you could also research the issue with your new lawyer, if you're going to get them hired that fast, as to whether or not you are currently entitled to a jury trial. So you both can bring in something that says this, and I'm going to give you a date to do that.
I see he didn't make any statements after she said that.
Okay, so let's get this appearance date. Where's Jess? Okay, so let's get a date for this pre-trial first, and we will have you file your responses to the jury trial issue by this pre-trial date.
Available April 11th, 2:45.
So wait a minute. So April 11th. At 2:45 is the pre-trial. So I'm going to ask for some heads up on the motion before April 11th. So that would be, let's say about, if you all could get whatever you're going to be filed by April the 1st, that would be great. So that gives you approximately a little bit over 2 weeks to look at it and just file whatever. You make sure you serve the other side, so with whatever you file, he knows to serve you. Okay.
That's it.
April 11th.
Yes.
Filing by the report.
Yes. Do y'all need an order that says that?
No, Your Honor. Thank you.
So that way we can try to decide this issue on the pretrial date. And then we will also be in a position to set whatever kind of trial date we're having. We'll do that on April the 1st. Now, Mr. Gromer has requested escrow.
Your Honor, if I may. I think one of the issues here is basically an understanding of the amounts that are owed. I think we had an issue with that consent.
Yeah.
And they continue to need to verify those numbers.
Okay.
So to be fair, there are some complaints that we will be bringing.
Okay. What's that got to do with escrow?
Well, there may be some injury and some value that may be acquired from the plaintiff for us as well. So
Sir.
I'd like you to take that.
Oh, no, the court was clear. If possession of the property is at issue, which is, it is, the plaintiff shows a need for protection, which they need the rent, the court can order escrow. It would be prorated, it should order escrow from today's date to the end of this month. And then you would pay escrow to whatever, till rent is due, which would be the next date, I guess would be April something. And then that would be whatever the amount of rent that you normally pay. And you'd keep paying that every time rent's due till we have the trial. It doesn't go to anybody. It goes to me as the court. Then once you have the trial, if I decide, yep, this was the amount of rent due, but there's issues and, you know, your ability to have the premises was affected in some way, and I give you credit against that, then part of that escrow may go back to you. That's what it's there for. It's for the protection of the plaintiffs, because I think the rule is there so that, you know, people want to relet their places, whether it's apartment or house, they want to do it quickly. That's why they call these summary proceedings. They're not meant to last for months. They're meant to kind of be heard quickly and get resolved quickly. And so we want to have the money sitting there because we don't want people to just drag a trial out. And then if they lose, they don't have the money to pay. So that's why they put the money in escrow. And that's what the rule really is for. So I will order it because the rule says I should, since I'm putting this out now past a trial date. I don't even have a trial date. I'm having a pre-trial because you want a lawyer, which is fine. But escrow would normally be required in this instance. So let's see. You can agree on what the monthly rent is, right? How much was it in monthly?
1660.
5550 page.
Okay. I was going to do that, but if that's what you said. Yeah, there is. That's why I would usually do this myself. 1665. 31 is 5370.
Yeah.
71 if you want to go over. 5371 per day. And then I've got, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I've got 12 days here left in March. So it would be 644 and 52 cents that you would have to put in escrow with the court. And that would have to be due 7 days from today's date. Then you would pay the 1665 to the court. If your rent's due April 1st, you pay it here on April 1st, but there is a 7-day grace period. And that's what the order says. And then they do not accept personal checks or money orders. Acceptable payments are cash or certified bank checks payable to the 46th District Court. Okay, so let me see. And I'm not sure, Mr. Gromer, I think I saw something in my, in one of my queues here that the Pallets firm was requesting to be removed from getting notices, but we're trying to figure out how that happens. So I'm not sure if you're getting notices on these cases.
They keep setting it.
Okay, but I haven't signed the order because we're trying to figure out how to get it out. Yeah, it's something in the system and it's real tricky. So So let's do this order now, 6/44/52. 7 days from the date of today, or might be, yeah, today. And then you're gonna pay $16.65 per month on the rent rent is normally due. Your RP number, Mr. Gromer?
63503.
65
63503.
50. All right.
Honor, if I might, could you on those dates for the escrow?
Yes. So, 7 days from the date of the order. I'm hoping I get to this order to be dated today. And then the next payment, your normal rent payment, is due whenever your rent was due. If it's due April 1st, pay it here April 1st, but we do give a grace period. All right, so I'm getting ready to send this to myself, I think. And we'll get it signed hopefully today. So I think we're gonna be good there. The order just went up there somewhere for me to sign. And I've got the next date being April 11th at 2:45 for pretrial. And then the brief on this jury demand issue is due April 1st to give you a chance to look at it. Okay, anybody have anything else?
You say that about the jury trial information, you said refund? I thought you said the refund is due April 1st.
No, I said the brief on the jury trial issue is due April 1st.
Thank you, Judge.
All right, thank you. You're both all set. And make sure you get his number to your lawyer as soon as you hire one, okay?
Yeah, I'm gonna grab this up, Mrs. Carter.
Okay, great.
All right. So originally at the end of the video, I said, okay, we'll see on the second hearing if he's a sovereign citizen or not, because he really didn't say much. And it just seemed like he was stalling the case from other hearings and the background information that I gave you. Now we going back in, and now you about to get your answer. Okay, let's go.
Well, let's start it. Case number 2412369 LT, 42 West versus DK Inya. ENYIA. All right, appearance for the record.
Your Honor, James Gromer, P63503, on behalf of plaintiff. Your Honor, can the person appearing on behalf of 819-605.
All right. And today's the date scheduled for a trial in the matter. Last time we were here on the 14th of May. Mr. Butcher, the plaintiff defendant did not have counsel, but had someone retained, who Mr. Butcher indicated had spoken with counsel plaintiff that day. And that they were working on settling the case. And so
those are notes for this case, Your Honor. That's not this case.
Okay.
Mr. Demers was not.
well, let me see what do I
Mr. Boucher. Great.
see? What happened here? What case is this?
My parents on the 16th.
James Cromer. Oh yeah, these notes don't go with this case. This is 42 West. Oh, it's a 42 West, but not the right 42 West. Okay, hold on. All right, I've finally pulled up the case file here, and my notes now say that we were here on the 11th of April with Timothy Prochko for Mr. Gromer, and the defendant appeared, and this was the motion for the jury demand. Okay, so I guess we're here today to find out if you've settled or to see if we need to proceed. So, Mr. Demers, where are we with this?
Your Honor, can you give us 1 minute?
Yeah, I was gonna say, we can take a brief recess.
I think we're ready.
Okay, let me just, that's one thing. Jessica, can you start that? Oh, she started.
I think she did.
She did. Okay.
Yeah, it's a Monday, something.
Go
Okay.
bench. 42.
Your Honor, do we have forms here?
For what?
Additional dismissal? We have that form later.
We can submit it. We can submit it out.
Yeah, even if you fill it out, you still gotta go. Yeah, you have to still e-file it, scan it anyway, even if we do have the form. All right, so this is recalling case number 2412369 LT 42 West versus DK Inya. All right, appearances again.
Thanks for P63503 on behalf.
And the verse for the 116.
Great, thank you. And so council wanted to take the opportunity to kind of talk to see if you could resolve the matter. And it appears that you may have come up with something. Is that right?
We have your in place closed terms, the play on the record, and then great.
Okay, hold on just a second. Let me type something in. All right, go ahead.
Your Honor, this case was filed as an missed to a termination. The lease was one. And he is going to retain possession until September 1st. As long as he pays June, July, August rent by 5th. That total is $1,865
Total
each month.
1865
Yes, Judge.
a month
Yep. And he
for
understands.
June. You said that's June, July, and August.
Yes.
Okay.
If he is late on any of those payments, we can ask for a reinstatement of the case and an eviction. But it won't be a dollar amount only. Just want to make that clear.
And this is terms of a conditional dismissal.
Correct, Your Honor. And then the only remaining item, which is just, you'll see it on there, is the parties agree once only, even though it's a termination. This is because he wants to be able to make arrangements, and we're fine with that. It's 53/57/40. And so if I were to reinstate the case, Judge, I'm not using that amount as anything owing. That 53/57/40 is just something that the parties, well, he's going to make arrangements to pay that, and we're agreeing that we're not going to expect any payments until, I'll actually go into September, until October 1st. And how many months did you want on that? Week and 12 months. And he's going to make 12-month payments on there for that amount.
But that is not being.
So it's going to be on the judgment, but it's nothing a condition he has to do at any time. So it's just for purposes of agreeing that that's the amount only.
Not a conditional judgment.
Correct. And obviously, if he doesn't make any of these payments and lives in the property, obviously. So then I think those are the terms of the.
Did you have anything you want to add, change, tweak?
Other than what I mentioned to brother counsel, we would just take the opportunity to notify them if anything was held up in it. Like rent.
So what does that mean? Because
15 days.
is that in there as part of the agreement?
Periods.
Oh, you're not gonna.
No,
Okay. So
I'm not charging any fees to be late. I'm just asking. Doesn't make.
5-day grace period.
It's still early. Oh,
All right, so what I've got is that we're going to convert this to termination of tenancy. The conditional dismissal will enter with the defendant retaining possession till September 1st, as long as he pays $1,865 a month for the months of June, July, and August. And there will be a 5-day grace period on those payments.
Well, fine. Sorry.
5-day grace period on the payments, but if he's late, the case can be reinstated and eviction entered with no dollar amount owing. That the parties agree amongst themselves, and it will be on this, I guess, dismissal form, that $5,357.40 would be the amount due, but this is not being owed, but for the parties to make some payment arrangements down the road beginning in October 1st for a possible 12-month period. So it's on the judgment, but not a condition. It would be on the judgment or the dismissal, but not a condition of it.
Okay, the deal sounds kind of strange. What I'm thinking about is that he paid an attorney money, which could have probably went towards his rent.
All right. Do you need a voir dire your client or not? You don't have to.
That's fine. Mr. Enya, he set out the whole was prayed for and the complaint was accurate without regard to some costs that without regard to the cost of the victims. Figured those were reasons.
Is that yes? Are you agreeing to what he's saying? Okay.
And when I ran the numbers and I created the rent account payments that you had received, those payments that you paid, the rate that you were supposed to. And you saw the column where the rent was accruing and we had a declining balance. And payments.
Yes.
Even to the amount that it still on the record, 53, 57.40, is that what I? Yeah. So you realize also acknowledge that their number is slightly higher because it accounts for some of the costs and late fees. So on and so forth. Agree that there is roughly $1,000 difference. They agreed to pay $1,000. Bring the balance to 53, 57. I have one more question.
Is, so there could be damages, but assuming there's no damage. Positive. 53.
You know what, right to do.
Yeah, just asking. Easy. Which just makes more sense.
That's fine. She a little lot less. That's fine.
Okay.
Okay.
Good.
All right. And who's submitting the conditional dismissal? Okay. All right. Good.
Are okay about what I said?
Yeah. If you want to just submit it, if you've looked at it, I mean,
If not, I can submit it onto the Saturday if for some reason there was a disagreement.
well, if you want to do that, that's easy.
Or skip it, but if for some reason we lost our minds and didn't agree, I would do it then.
You seem like you're agreeable now, so I can't see that being a major problem. But you never know.
Myself was electronic means of, deemed to be quicker.
Mm-hmm.
Yeah, we should be able to do it. You can't do it until whatever else gets back and does the
That's true. You can't.
like. So that's probably longer than what we. Cognizant of. Not, ordinarily customary, you have a judgment at the same time.
Take care, all. Thank you.
Later.
Right. Made those changes, and that completes the docket here.
Okay, so the answer is he's not a sovereign citizen. But in the first hearing and the things that was heard there, I thought maybe he was because he wanted to go to jury trial over him not paying his own rent. So it looked like it was a stall tactic, or maybe he was going down that route and decided he wasn't going to do it. And as previously stated in the beginning, I missed a couple of hearings, but this thing had been stalled out for a while. So we'll see what's going to happen with him. If he comes back on the radar, I'll check it out. I'm wondering if he's even going to pay that rent since he went through all of this stuff. He paid an attorney, which he could have just used that money to pay his rent every month. Who knows why he's not paying it or didn't pay it or got behind. I don't know. But I promise to follow up there's the follow-up. We found out he's not a sovereign citizen. So hope you enjoyed it anyway. I know the audio can be a little challenging in this court, but hope you have a good day, evening, or night. See you around on the next one.